The challenge I have with that is the filing spouse is deemed the breaching party unless substantial grounds exist. Now, anytime there is a term in legislation that has a subjective definition, my radar goes up. So I'm on the legislative committee of the New York State Bar Association Family Law Division. So I help write and shape the legislation that is reviewed by the New York State Legislature for the purposes of the Domestic Relations Law and the Family Court Act, which is really the two sets of laws that govern everything related to family law in the state of New York. And every state has their own versions of that. So I'm always looking for things like substantiated, or when you make a presumption, you're creating what we call in the law burden of proof. So, fundamental to our judicial system, for those of you playing at home, is I don't have to, if I'm accused of a crime, prove I'm innocent. The state has to prove I'm guilty. I can just sit as a lawyer and punch holes in the state's case. I don't have to call any witnesses. I don't have to prove my client is innocent. They have to prove my client is guilty. And the burden of proof in criminal cases is obviously beyond a reasonable doubt. A little lower than that as a burden of proof is what's called clear and convincing evidence. A little lower than that, the lowest level of proof, is what's called by a preponderance of the evidence, meaning that you've proven something is more likely than not. So in this situation, you're flipping a burden of proof. You're essentially saying whoever files the action is presumed to have breached the contract of the marriage unless substantiated grounds exist. So that's going to make
I was
the
thinking
fault grounds incredibly important.
Yeah, well, that was the whole point, and this is where I agree with you, and I when you talk about no fault divorce, all it did was expedite divorce process. People were already going to get divorced regardless.
Right.
The relationship was over, and I agree with that. But this actually made it to where okay, somebody couldn't just kind of like what China did with their law. And we're gonna get into that here soon. But the whole point was okay, there would have to be some justifiable reason. If you're going to file for divorce, because from my understanding, divorce divorce law is the only contract that can be broken where if you decide to breach the contract, you could also be the rewarded party, with alimony, and the other party did not want the contract to be breached, and they still wanted it to work, but they're the injured party, and they have to pay. And so to me, it's looking at it from contract law, anybody that breaches a contract would have to pay the injured party, and the injured party would be the person that would,
unless there was a basis. I mean, there are, of course, in contract law, a tremendous number of basis for the breach of a contract, meaning frustration of contract, failure of consideration,
and that would be the substantiated grounds exist.
Yeah. So the challenge is, I practiced law when we were a fault-based state. So I've done grounds trials. And the interesting thing about grounds trials is the interesting thing about being a lawyer, which is it doesn't matter what I know. What matters is what I can prove.
We can prove, yeah.
And so what's very challenging in this situation is proving who is at fault in the complex ecosystem of a marriage. Because again, how we define abandonment. So if a woman has just decided I am not having sex with my husband anymore, is that abandonment? Now, under fault grounds, there was a concept called constructive abandonment, which was if you did not have sex with your spouse for a period of 1 year and there was no physical incapacity that rendered you unable to have sex with your spouse, that was considered abandonment. Once per year. So that was considered. Anything less than that was a basis for divorce. So you're telling me once a year, if your spouse has sex with you, if the rest of the time, the other 364 days, they refuse to have sex with you, that's not abandonment? That seems crazy to me. But the challenge becomes, how do we codify this into law? So one of the things I just want to take a step back before we take a step forward. Fundamentally, you are doing what a lot of people have done. And again, I think with good intentions and a good rational perspective. When the actual details of it come in, it gets a little more challenging. But you're focusing on barriers to exit. You're saying, look, we got to make it harder to get out of these. We got to make it harder, make people take marriage more seriously. I actually don't believe you're going from the right direction. I think barriers to exit is not the solution.